What is leaving the scene of an accident, hit and run, VTL Section 600? Being involved in a car accident is often a chaotic experience. In the panic that follows, some drivers make a devastating mistake. They drive away without stopping, sharing their information, or notifying the police. Under New York Vehicle and Traffic Law Section 600, this action, commonly known as leaving the scene of an accident or hit and run, can turn a minor fender-bender into a criminal charge. Understanding your duties at the scene is the first step to protecting yourself under the law. In New York, the statute is clear. The offense is not about who caused the crash but about a driver failing to perform specific duties imposed by law. Section 600 requires every motorist involved in an accident to stop, identify themselves, and, when there is any injury, promptly call law enforcement. The law creates a strict affirmative obligation regardless of fault or the severity of damage. Failing to stop and report means the case can be prosecuted on the criminal docket rather than in routine traffic court, and the penalties rise sharply when injuries are involved. So what exactly is leaving the scene of an accident? It is the crime of departing from the site of a collision without stopping, exchanging contact and insurance information, and providing aid or notice to authorities as required. Whether the incident involves property damage or personal injury, driving away violates the statute and exposes a driver to fines, potential jail time, and a permanent record. Under Section 600, you must immediately halt your vehicle at the place where the damage occurred. You must show your driver's license and insurance card to the other party. You must also give your name, address, insurance carrier, policy identification, and license number. If anyone is hurt, these details must also be provided to a police officer at the scene. The law applies even when the other driver seems to be at fault or when the damage is minor. Leaving a note on a windshield does not satisfy the requirement. In fact, when the owner of a parked vehicle is not present, the statute requires you to report the accident as soon as physically able to the nearest police station or judicial officer. Your legal duties. What NY law requires after any accident? These duties apply in every collision, including those involving parked cars or unattended property. Drivers who fail to stop and report often face charges under Section 600(1) for leaving the scene of property damage. Although this violation is classified as a traffic infraction, it carries penalties harsher than most moving violations: up to 15 days in jail, a fine up to $250, and 3 DMV points. Cases can be heard before a criminal judge. VTL Section 600(2). The criminal charge for personal injury. When a driver leaves an accident that causes injury, the offense escalates. Even minor soreness or bruising meets the broad definition of personal injury under the statute. The penalties follow an escalating ladder depending on the seriousness of injury and prior convictions. Failing to show a license or insurance after a minor injury is a Class B misdemeanor punishable by fines between $250 and $500 and up to 90 days in jail. Failing to stop or report after an injury is a Class A misdemeanor with fines between $750 and $1,000 and up to 1 year in jail. A second offense or an accident involving serious physical injury is a Class E felony punishable by up to 4 years in prison and fines up to $5,000. If the accident results in death, the offense becomes a Class D felony with up to 7 years in prison and fines between $2,000 and $5,000. Serious physical injury is defined as an injury that creates a substantial risk of death or causes protracted impairment or loss of a bodily function. The core of your defense. Knowing or having cause to know a charge under Section 600 is not strict liability. Prosecutors must prove beyond a reasonable doubt that you knew or had cause to know that property damage or personal injury occurred. Courts look at both what you actually knew and what a reasonable person would have known under the circumstances. Defense strategies often focus on showing that the impact was imperceptible, that environmental conditions masked the event, or that the damage was not visible. If the prosecution cannot prove that you were aware of the collision or injury, the case collapses. A skilled defense attorney will gather physical evidence and witness testimony to demonstrate that you reasonably lacked knowledge. Leaving the scene of an accident is a serious matter in New York. The statute imposes specific duties and harsh penalties, but it also provides defenses when you genuinely did not know an accident occurred. If you face a hit-and-run charge, seeking counsel from a lawyer is crucial. An experienced attorney can help you understand the nuances of Section 600 and protect your rights. At the law offices of Jason Bassett, P.C., the law firm offers results-driven representation for clients in Suffolk County and beyond. This law firm is located at 320 Carleton Avenue, number 4200, Central Islip, New York, 11722, and you can reach them at 631-259-6060. Contacting a lawyer promptly can make the difference between a conviction and a successful defense.